Here are the 3 big misconceptions that creators tend to have about intellectual property law. I'm an entertainment attorney, and on this channel, I talk about the legal issues that artists, athletes, and creators face in the entertainment world. If you want to hear more, follow along. This one comes in a lot of different flavors. Sometimes people say you can use 4 bars of music, sometimes it's 3 seconds, sometimes it's 7 seconds, but the reality is there is no magic number for the amount of audio you can sample without possibly infringing on someone else's copyright. Anytime you're copying any amount of that sound recording, you're potentially infringing on 2 copyrights, the sound recording and the musical composition. The long answer is it could possibly be fair use, but that involves a detailed analysis, and you never really know the answer until a court rules on it. The short answer is there is no magic number for using someone else's audio. This one's confusing because on the one hand, it is true that you do have copyright protection regardless of registration as soon as your work is fixed in a tangible medium of expression. In the United States, if you want access to all of the benefits of copyright protection with attorney's fees and statutory damages if someone infringes, you have to register timely and accurately. It's really easy for creators to use copyright and trademark interchangeably and not really understand the nuance of difference between the two. Let's take music, for example. If you're an artist, write your own songs, record them, publish them, release them all on your own, you own the copyrights in your music and the sound recording of your music. Generally speaking, copyrights protect creative expression. On the flip side, trademarks exist to protect consumers from confusion in the marketplace. What that means is your band name when you're on tour is probably protected by trademark law. If there's another band out there touring with the same name, there's a likelihood of confusion in the marketplace. That's what trademark law exists to protect against. It doesn't really matter how creative or unique your band name is. The law is there so that when people buy a ticket, they know who they're going to see. Of course, there can be some overlap in these two things, but it's important for creators to understand the difference when they're talking about their intellectual property. If you're interested to hear more about this kind of law, like, subscribe, and follow along for more. See you in the next one.